Hello everyone, welcome to Sunya IAS and welcome to this lecture. Today we are going to talk about a big threat to Indian democracy. And if it is a threat to Indian democracy, it of course is very important from our UPSC perspective. What we are going to talk about today is sealed cover jurisprudence. Now what is this? थोड़ा सा नाम से समझ में आ रहा होगा. Slight, you'd be able to understand with the name itself. It's something related to sealed cover. Something is going from somewhere to somewhere in a sealed cover. That means there is no transparency to it. So when we talk about sealed cover jurisprudence, we are talking about a form of information exchange. Information exchange wherein information is being provided to the courts of India. So it can be a high court, it can be a Supreme Court. Information is being provided to them, and this information is being provided in a sealed box, sealed cover. That means that Supreme Court or High Court cannot actually disclose the details of what is there in this sealed cover to the public, to the media being the fourth pillar of a democracy. So that is the thing. And it is not necessary that this particular information comes only from the side of the government. It can come from any side. It can come from the side of the civil society. It can come from the side of NGOs, anything. But the fact is that it is in a sealed cover and public does not have access to that information. So when that happens, it means that the basic principle of democracy, that is transparency, is being impacted, right? Transparency is being impacted. Now, before we move on to discussing the topic in detail, let me just make a few things clear. First, as I always tell you in the beginning, about the notes. So for the notes, you have two options. If you want to get the notes of this particular class, you can either go for the Sunya books. Okay. So this sealed cover jurisprudence will be in GS2 book, right? You can go for the Sunya books, you can order them, or you can make handwritten notes. Okay. As the class proceeds, you can slow down the class, you can, fasten it if you want to, but you can actually make handwritten notes along with the class if somehow you don't want to go for the Sunya books, whatever your reasons are. But all these topics, these are there in the Sunya book, so you can take our GS books. That is there. This is about the notes. So please don't drop in the comments where can I find the PDF of this particular lecture. I have already told you, either they are here or you can make them yourself. Make sure if you're making handwritten notes, you are properly dividing them into 4 aspects. So let's say this particular aspect is most applicable in GS2, right? So I'll also tell you where else it is applicable, but you put this particular aspect, put this particular topic in your GS2 file, right? And make your notes in A4 size sheets, arrange them properly, index them, page number, etc. All of this is important. So this is one. The second thing is where this topic is important. So the topic is sealed cover jurisprudence. It is important in 3 aspects. One is GS2, very clear. It is an issue that is faced by the Indian judiciary. And because the issues related to judiciary are often in news, you can even get a separate 10 marker asking you what is sealed cover jurisprudence, how does it impact the independence of judiciary, how does it impact the information dissemination to the people, right? So a multi-dimensional question can be asked over there, right? Just a second. So that is one. The second thing is, the second place where it can be asked is in GS4. Now, do you think that it will be asked as a separate question? No. But when you get a question of transparency and you have to give an example where transparency is being violated, right? You can give this example of sealed cover jurisprudence that is happening in the judiciary, wherein central government is giving information in sealed covers, right? Another very important thing is your essay. Okay. So because we have philosophical essays, you can write anything and everything at a proper place. And when you write things like this, which are happening around you, you will actually get to gain a few more marks. I'm not saying that just writing sealed cover jurisprudence will give you excessive marks over than the others, but overall understanding, right? So any topic that we cover, it will have one base subject, that is one base paper, and some peripheral papers wherein this example can be used. So always have that multi-dimensional perspective. Okay. This is what I wanted to tell you in the beginning. Now let's move on. The meaning of sealed cover jurisprudence. So you can write down the meaning of sealed cover jurisprudence. It is the practice of seeking and accepting. It is a practice of seeking and accepting information. Please write it down. Seeking and accepting information from government agencies, and not just government agencies actually, from government and non-government agencies in sealed envelopes to maintain their secrecy. To maintain secrecy. This is the basic aspect of it, that you are accepting. And who is accepting? The judiciary is accepting. See, whenever judiciary wants to give a judgment, judiciary will give a judgment on the basis of facts, right? So when it will give judgment on basis of facts, it will need facts from the government agencies, right? And you will not believe in what all cases the sealed cover jurisprudence has been used by the government of India. That means government of India gives some facts to the court, but the court can't reveal it to anyone, be it the media or the people. So just make a list of some of the cases. So there was this fake encounter case of 2002, which is commonly known as the Godhra case and the post-Godhra riots of that time. Then there is sealed cover jurisprudence used in Narendra Modi's biopic case, right? The biopic of Narendra Modi, our Prime Minister of India, which was made, some details about it in sealed cover jurisprudence, because there are always challenges to these kind of political and politically motivated content, right? Then sexual harassment case against ex-CJI. इसमें भी there were some details that were required and they were given in sealed cover, and you don't need to write the name. Name was of course Ranjan Gogoi, you all know that, but you don't need to write that name in your paper. Then even in Ayodhya dispute, sealed cover information was shared, and most recently the electoral bonds case. Okay, these are some of the cases, and one very important case because of which all of it came into news was the One Media case. Media One case, sorry. Yeah. Just a second. Yes, the INX media case I'm talking about, right? INX media case, also called the One Media case, wherein the channel itself was banned and there is no clarity in the public domain on what basis it is banned, why it is banned. There is no clarity at all. And in a democracy, if you are trying to stifle the freedom of speech like this, then what will happen to the democratic credentials, that you can understand. Okay. So let's talk about where does the Supreme Court get the power from, and where does the government of India get the power from to engage in these kind of secretive activities to which people do not have any access. So there is rule 7 of order 13 of the Supreme Court rule. So when you write it in examination, you just write Supreme Court rules, rule 7. No need to write so much because you don't have that much space in your answer sheet. So rule 7 of Supreme Court rules 2013, it actually tells that if Supreme Court has designated a particular file, a particular piece of information as a secret, then this secret cannot be used as an evidence by anyone, right? It shall remain to be a secret till the time the Supreme Court declassifies it. So it is basically the equivalent of Official Secrets Act, right? The executive has rights to designate some file as an official secret and not release it to the media, to the public. And similarly here, Supreme Court rules, rule 7 of order 13 gives the Supreme Court the right to actually designate. And when I say Supreme Court, specifically I'm talking about the Chief Justice of India. Chief Justice of India has that right, right? And similarly, Section 123 of Indian Evidence Act is just a corollary to these Supreme Court rules. Same thing is being said, that any document which is designated as a secretive document shall not be revealed or shall not be used as an evidence. Okay. So this is a source. So that means the sealed cover jurisdiction has a statutory basis, right? Although there is no law or there is no such statute which says that something called sealed cover jurisprudence actually exists, but in practice it does exist. Now here you have some of the instances apart from what I told you, right? The sexual harassment case, the Ayodhya case. There are very famous cases wherein government shared some very important and crucial information which till date is not available for the public to scrutinize. What was that information? Information regarding Rafale aircraft case. Of course, the corruption which was alleged in the Rafale aircraft case. Some details were provided. We don't know what they were. Bhim Koregaon riots case, right? These are the caste-based riots which happened, and Bhim Koregaon riots case also. We do not have the evidence which was submitted by the Maharashtra government over the rioters. So whenever riots happen, you need to understand that state does attack the rioters. And you know, जैसे एक bulldozer justice की बात होती है when we talk about UP. So on what basis do governments decide that this person was a rioter? Because in riots it's very difficult to identify people, right? So similarly, Bhim Koregaon case, Maharashtra government did implicate some people, calling them rioters, but it did not release publicly the kind of proofs that were there against them. Then 2014 BCCI reforms case, the cases of corruption in BCCI that were reported. So information was provided, but it is not there in the public domain, right? So the information here was provided by BCCI itself. Okay. Then NRC exercise in Assam. the National Register of Citizens, a very long standing demand but a very controversial aspect also. So mostly, see, even before going towards the rationale, what can be the rationale, you already know that the rationale has something to do with public order, with public security, right, with public trust. So these things you have to understand, right? Then Alok Verma case. Alok Verma case is related to the corruption allegations against this particular officer whose name was Alok Verma, and he was former CBI director. So see, the purpose here again is that the faith in organizations like CBI should not reduce because of one person. Okay. And how to use these examples? You use these examples along with the points when you support or when you oppose the sealed cover jurisprudence. That is when you use these examples. There is no point of writing all these examples in your answer sheet at one place and not applying it with pointers. They always have to come with pointers. Okay. And the 2G case, the 2G spectrum allocation case also. So Government of India gave some details about it, and they're not in the open on what basis spectrum was allocated, you know, all of that. So these are some of the instances. Now, judiciary has been very, very clear that sealed cover jurisprudence is not to be made a norm. Okay. So, for example, in P. Gopalakrishnan versus State of Kerala, and this is a very recent case, so you can simply write the P. Gopalakrishnan case, right? You don't have to write State of Kerala and everything. In this particular case, it was actually Supreme Court who said that disclosure of information is constitutionally mandated. It is constitutionally mandated. It is not something that can be a prerogative of the central government or a particular central government agency. No, it is constitutionally mandated. So if it is constitutionally mandated, so that means which right are we talking about? कौन से right की बात कर रहे हैं हम? We are talking about right to information. है ना, पब्लिक को हक है कि उन्हें पता हो कि सरकार क्या कर रही है, क्या स्कैम है, क्या डिटेल्स हैं, पब्लिक को ये हक है ना. People have the right, and RTI is there under 2 articles. It is there in Article 21, right to information. It is even there in Article 19. Not explicitly, but over the Supreme Court judgments, it has been immensely clear that right to information is a part of both these articles. Fine. Then INX media case, that is also a very recent case wherein this news channel was banned, and overall this case does not have to be cited because this is a very important observation that is made, that it is constitutionally mandated. In the INX media case, it was just that the Supreme Court was criticizing the Delhi High Court. So the Supreme Court was criticizing the Delhi High Court because Delhi High Court upheld the ban on this one media one channel, right? So INX media case. Then Model Dental College versus State of Madhya Pradesh. Model Dental College versus State of Madhya Pradesh. Here it comes that Supreme Court has given very detailed basis on the basis of which you can actually stop the flow of information towards people, right? So you hold this particular case. I will tell you at the end of this lecture what are the bases, because this particular judgment will come in way forward, right? When it comes to sealed cover jurisprudence, you will have to give way forward, and in way forward you will give this particular judgment, because here Supreme Court has given some basis on the basis of which आप sealed cover में information share कर सकते हैं, और आप उन्हीं basis पे सील्ड कवर में इंफॉर्मेशन शेयर कर सकते हैं, अदरवाइज इट इज अगेंस्ट द प्रिंसिपल ऑफ ट्रांसपेरेंसी, इट इज अगेंस्ट द प्रिंसिपल ऑफ डेमोक्रेसी, इट इज अगेंस्ट द प्रिंसिपल्स दैट वी स्टैंड बाय. Okay, now this is a sun type diagram. This is very useful, but in questions like these, आप मेंस में सन टाइप डायग्राम में आर्ग्यूमेंट्स इन फेवर एंड आर्ग्यूमेंट्स अगेंस्ट नहीं दे पाएंगे, राइट? सो व्हेन यू आर एक्चुअली हैविंग अ शीट लाइक दिस, राइट, इट इज अ शीट लाइक दिस, नीचे मार्जिन नहीं होता है यूपीएससी की शीट में. ओके, सो हियर is your question, and the second sheet you have, it is here. Okay, so when you're talking, आप यहाँ पर इंट्रोडक्शन लिखते हैं, यहाँ पर कुछ आप बेसिक फैक्ट्स दे देते हैं या फिर एग्जांपल्स दे देते हैं कि सील्ड कवर ज्यूरिस्प्रूडेंस जो है वो यहाँ पर यूज हुआ था. 2-3 एग्जांपल्स आपने दे दिए. देन आर्ग्यूमेंट्स इन फेवर जब आप लिखना शुरू करते हैं तो यू कैन यूज आइदर दिस फॉर्मेट 1 2 3 4 5 लाइक दिस. Why? Because it will help you utilize the entire space. As compared to this, अगर आप ऐसे लिखते हैं 1 2 3 4 5, तो आपके जो points हैं they will keep on ending here, right? And all this space is being wasted. Okay. This one will accommodate more points. This one looks very nice also. It gives a tree kind of format. So you can use this particular thing. Or if you want to, you can also go for this. Okay. Wherein here you have written on this particular thing arguments in favor or something like this, and you have made the pointers. But then again, I feel it wastes more space. I find this kind of a flowchart most efficient to write as many pointers as you can. Fine. Now, like we do, like I ask you to do, you pause your screen right now and you think about the pointers that can come in favor of this particular sealed cover jurisprudence. Think from the perspective of judiciary, think from the perspective of government of India, think from the perspective of the public, of the media, of international organizations, everything. And when your brain starts working like that, that you think in every aspect of this, that is the time when you are able to break down the points and generate points on your own self, by your own self. So the first, I hope you have paused and now moving forward. First point is it helps protect sensitive information. Here you give examples one by one. Okay, so for example, the Rafale deal, the Rafale case, it is related to our aircraft procurement, defense expenditure, and it becomes very important that we protect this sensitive information. That is why it had to be in sealed cover. Then it avoids prejudice. How prejudice? Among the mass media, among the people. Because during investigation, if you give TMI, that is too much information if you give, then it will be problematic for you. है ना? Because mass trials will start happening, media trials will start happening, and you can't stop them. Smallest of information, if it goes to the media, it creates a havoc. It has a domino effect, right? So that is why it avoids prejudice. Okay. Then it also lets experts analyze the kind of issues that are there. Okay, so whenever you are having a technical issue, let's say talk about Rafale only, you need the assistance, you need the help of experts to actually understand. So for example, if you want to go for the case of BCCI corruption and reforms case, wherein BCCI gave some inputs, you will need the assistance of people who are experts in cricket, who can understand that how this entire scam and how this entire corruption scandal was engineered, right? Then protection of individuals. If we release the name of people who have been involved in certain activities and whose names are being forwarded for, and it can be officers also. When you give the report of a particular riot, let's say Bhim Koregaon riot, so there will be some particular officers who would have taken action against people. And if the names of those officers come out in the public, their safety might be threatened, their security might be threatened. So, see, it is very easy to comment upon sealed cover jurisprudence from a distance. But we have to understand that if a practice has held its ground for so many years, there has to be a particular reason for it. And it is not to say that reforms are not required. Definitely reforms are required. But even with those reforms, we need to understand the basics. Same for Official Secrets Act also. Why do we still have Official Secrets Act? Because our media, our public, our, we as a people, we are not that mature to handle such sensitive information. During the Kargil war, everything, because media had access to the area, and some very famous journalists like Barkha Dutt, they came and they covered, they went and they covered the Kargil war. And it is documented that because of their coverage, many things that India was planning or India was trying to do, they were visible to the opposite side, that is Pakistan. Same with the 2008 Mumbai terror attacks. Everything that was happening was being live streamed from the Chhatrapati Shivaji, railway station and the Taj Hotel and whatnot, right? Everything was being live streamed, and then that live stream on the TVs was being used by the terrorist network to actually guide and everything. So I'm saying our media is not that mature that way, and that is why we need to protect the individuals so that mass shaming cannot happen. Then we need integrity of investigation. This is in follow-up of this particular point, that whenever a case is being investigated, you need to keep some facts secret before you can tell it all to the public, because they are still being investigated. They are not clear, right? We saw how during the Arushi Talwar murder case, every small happening that was, every small step that was being taken was being mass reported. Similarly with the Nirbhaya case also, right? So information is accessible to everyone, so we need to keep it down. And there can be some international commitments as well, which make us stop the sharing of sensitive information publicly. Okay. So these are some arguments. There can be some more arguments that you thought about, and it's good that you were, if you were able to think of some pointers which were beyond these particular points, because again, I'm telling you, UPSC examination is all about challenging yourself. So if you are just satisfied with these pointers and you are very happy that, okay, now I'll be able to remember everything, that is not how your brain will function, because you have not created these pointers, right? So if you have some more pointers that why sealed cover jurisprudence is suitable, please drop it in the comments and I will appreciate that. Please drop it in the comments, because that shows that you have some kind of critical thinking. And critical thinking is a sine qua non. What is sine qua non? It is non-negotiable aspect. Critical thinking is a sine qua non of this particular examination. If you don't have it, you are not going to clear this exam. So my goal always will be to make you capable enough to think without me telling you the pointers as well. Okay, that is why I emphasize a lot on not spending a lot of time on note making, on not spending a lot of time on just reading, but actually bringing your brain into practice through answer writing, through prelims question solving, right? These are the ways in which you actually practice your knowledge. Okay. Now let's move to the arguments against sealed cover jurisprudence. Please, again, I would suggest pause your video and think about these pointers, and then let's discuss these pointers. So I hope you've paused and thought about it and written it down, and now we are discussing one by one. So very basic pointer without any further understanding is that there is lack of transparency. Okay, basic principle of democracy is being violated. Then right to know versus national security का जो argument है, it is a very dicey, because national security is such a big terminology. National security is such a big umbrella that you can actually bring everything and anything under national security. So for example, the sexual harassment case against the ex-CGI, how does that relate to national security? Why was information related to that given in sealed covers? What was the need? It is very clear that principles of natural justice were being violated. So why was it happening? Right? There is no clarity about it. So this debate will keep on appearing that national security is important or transparency is more important. But in a democracy, if we do not want to become an Orwellian state is based on George Orwell's novel 1984, wherein he creates wherein he talks about a surveillance state where state knows everything, people do not know anything, and people are constantly being watched by the state, and people do not have the right to ask anything. So it will transform to an Orwellian state. It is also an obstruction to fair trial, because though judiciary is supposed to work on the basis of facts, it is a known fact that investigation agencies in India, barring Central Bureau of Investigation, National Investigation Agency, which are the central level agencies, the police is not doing its investigative functions correctly, right? So in many cases we see that because of the flawed investigation that police engages in, we end up losing a lot of critical knowledge, critical information about cases, right? So in that way, it is important that media is also involved, that people are also involved, and a fair trial can happen wherein every piece of information is being properly utilized. So that is there. Then there is of course scope for arbitrariness. Again, here take the Ayodhya case as an example. What was the need of giving the information related to Ayodhya Ram Mandir case in sealed covers? What was the need for that? Okay. Then it of course violates the principle of natural justice. Why? Just think about it. Because see, government is the largest litigant, and here in sealed cover jurisprudence, it is the government which is giving proof, government which is giving evidence, government which is giving proof, and the proof is very often against government itself. So how can government itself decide that this particular piece of information I'm going to share with people and this I'm not going to share with people? How is it that government gets to decide it? Right? So it is a principle of, it is a violation of the principle of natural justice. It is a violation of the principle of natural justice. Okay. Then the reasoning why a particular file would be there in sealed covers is not given actually. Okay, there is no justification. by the court orders. It's just that the government has said that this is sealed cover, and the Supreme Court ends up agreeing with it. And there was a different case related to this, wherein a Supreme Court judge, a recommendation for Supreme Court judge, why it was rejected. That particular sealed cover jurisprudence was released by the Supreme Court. So Supreme Court sent some names for being appointed to the Supreme Court as you know, as the collegium. It recommended some names to the cabinet, to the ministry, and for one of those people, for one of those judges, that particular judge was a homosexual, right? He was openly gay, and that was the reason given by the central government to not appoint that particular judge in the Supreme Court, in the bench of the Supreme Court. And this piece of information was released by the Supreme Court of India publicly. Okay, so now this becomes a arbitrary decision of the Supreme Court, what information it wants to release, what it does not want to release. It all depends on Supreme Court, right? So there's reasoning is not given. Opaque adjudication happens because the reasoning is not given and information is not available. Abuse of power both by the Supreme Court and by the government of India is happening, and this is where Supreme Court has now come forward and said that sealed cover jurisprudence needs to be curbed. We cannot be having all the information being shared in sealed covers. We do not appreciate it. Okay. Imbalance of power is being created because here the legislative wing is not in the know-how, it is not in the loop at all, right? There is imbalance of power, absolute authority is being given to the executive. Then it violates the rights of the aggrieved parties. So let's say, for example, the people who were implicated under Bhim Koregaon case, if they don't know why they were implicated at all, then this becomes a violation of Article 22 as well, because everyone who is arrested needs to be informed about their grounds of arrest, right? Then it promotes a culture of secrecy and it appreciates it. You know, we as a public, we appreciate this culture of secrecy a lot, which is not a good thing. Okay, so this culture of secrecy is developed, that is not supposed to happen. Now we have definitely talked about some of the judicial cases already. Media One case, INX Media case, we have talked about the Bhim Koregaon case. So just see where you can use these particular cases in your answers. Okay. As I told you, the way forward has to have this particular case, which is called Modern Dental College versus State of Madhya Pradesh. So Modern Dental College versus State of Madhya Pradesh, the Supreme Court gave some directions on which basis is the sealed cover jurisprudence is to be exercised. Okay, so just write down that sealed cover information can only be shared when it is for a proper purpose. Right? Proper purpose, definitive purpose, and that purpose is very objectively stated. Then second is the means used for gathering of that information are rational as compared to the purpose. So ऐसा नहीं होना चाहिए कि that you want to find out, let's say, a spy case, and in finding out the spy case, in finding out some information about the spies, you end up actually spying upon every journalist in the country. So there was this Pegasus case, I hope you remember. Even there, sealed cover jurisprudence was used. So it should not be the case that way, that you want to achieve a small output and you are actually overstretching your powers to achieve that in the name of achieving that output. The third thing which Supreme Court said was that sealed cover jurisprudence should only be adopted when there is no alternative measure, no alternative way to achieve what you want to achieve. Okay, so when secrecy is utmost important, let's say in a terrorist case, that is the time you use sealed cover jurisprudence, not for cases like the Ayodhya, the Ram Mandir dispute, etc. Right? And there has to be a proper balancing. There has to be a proper balancing between the purpose and means. This is similar to the second point. So you can summarize this particular debate, this particular case in 3 points. It has to have a proper purpose. The purpose and the means should be rationally related, should be able to justify each other. And there has to be no alternative way to achieving what we wish to achieve. And the sealed cover jurisprudence should be the last way to go for it. So that is how you will use this modern dental college versus state of Madhya Pradesh. This I have already told you that constitutionally mandated, it is constitutionally mandated. Again, I'd like to remind you to share information with the people. Then INX Media Case 2019 and overall Media One case. Media One case I was talking about, wherein the banning of the channel happened. There was no reason given why the channel was banned, why the publication of news from that particular channel was banned, but it was just banned. And this is something that is against our democracy, right? So in Media One case, it has said that Supreme Court is not in favor. Supreme Court is not in favor of sealed cover jurisprudence. So here you can just mention that Supreme Court in the Media One case mentioned that it is not in favor of the sealed cover jurisprudence. Fine. These are some of the cases. Now, objectively, apart from the modern dental college versus state of Madhya Pradesh recommendations, you have to write some recommendations here as well in the way forward. So there have to be clear guidelines on what will make a particular set of information in sealed cover, right? Clear guidelines, and by clear we mean objective guidelines. Okay, they have to be objective guidelines. And the usage of this jurisprudence has to be very judicious. Okay, from the side of the Supreme Court and the side of the central government or any government for that matter. Recently, the cases of sealed cover jurisprudence have been increasing manifold. It is not a good trend. Okay, so these issues have to be judiciously used. There has to be a balance between transparency and confidentiality, and this corresponds with the judicial usage aspect of it, that you use it only in cases where nothing else is possible. No possible alternative is there. Okay, and you need to explain the circumstances why you are presenting. So for example, the sexual harassment case against the ex-CJI, why would you present those facts in a sealed cover? They are not related to national security. They are not related to anything that comes in public order. Nothing. Why have you given it in sealed cover? So you need to make it very clear. And overall, you need to follow the constitutional principles according to Article 21, Article 9. Right to information is a fundamental right, and you need to accept it. So this question, let me repeat, this particular topic can come as a separate question also. This is one of those topics which can come as a separate question in a 10 marker or in a 15 marker. Where all it can be used, I have already told you in the beginning of this class itself. I have told you that in questions related to transparency, in questions related to, let me just write, In questions related to transparency in democracy. Then in questions related to judicial reforms. This is one of the reforms that we need to minimize sealed cover jurisprudence, and here you can write according to Model Dental College case. Then it can also be used in a question of executive excess. If the executive is recommending a particular case, is using sealed cover jurisprudence extensively, it is providing information in sealed covers extensively, it is overstretching its boundaries. Fine. So these are the issues wherein you can use sealed cover jurisprudence. If it comes in your prelims examination, you know what it is, you know the impact of sealed cover jurisprudence. So I hope now this is crystal clear that what sealed cover jurisprudence is and where it can come. So that is all for today's lecture. I hope you derived some value out of it. If yes, do let me know in the comments that you did derive some value, and keep watching. I've already told you about the notes. So if you want to know about the notes, just shift to the beginning part of this video and you will get to know. Fine, I will see you all in the next class. Thank you for watching.